welcome everybody. This talk today on adoption and immigration is part of the Mills and Reeve Family Matters seminar programme, and we're absolutely delighted that you can join us. And I am really chuffed to have Ruth Cabeza and Mark Benton join me. I'll first introduce Mark. Mark Benton is a senior associate in the Mills and Reeve employment team, and Mark has a background in family migration for spouses, citizenship applications and children. So Mark is a specialist immigration lawyer, highly experienced in all types of personal immigration matters and visa applications. He also advises on the sponsorship of migrant staff, and his work includes assisting with sponsor license applications as well as ongoing compliance matters. Mark's vast knowledge of individual immigration applications allows him to work with both employers and migrants to understand their particular issues and take a holistic approach to their specific needs. Mark's recognised in the Legal 500 and other directories as a prompt and responsive solicitor. Very pleased to have you join us this morning, Mark. Now, Ruth Cabeza, I've known Ruth throughout my career, principally reading her book, International Adoption, which has equipped me to be able to advise clients on how to adopt a child where there's matters of overseas complexities or children outside of the jurisdiction. Ruth is a specialist at Harcourt Chambers in all things children, specifically public law children, private law children, surrogacy, child abduction, financial remedy and medical treatment orders. She has far too many reported cases to mention. I'm always reading her cases in the law reports, and so I'm absolutely delighted to have Ruth join us. Just to get us started, I'll just briefly talk about the format. We're going to first hear from Mark with an overview of family immigration, adoption and British citizenship. And then Ruth will talk to us about the different kinds of adoption with overseas elements. And then I'm going to take questions at the end. You do have a question and answer function, but I think we're going to try and get through the talks by Mark and Ruth, and then we'll have questions at the end. Okay, thank you, Mark.
Yes, thanks very much, Zoe, and good morning, everyone. As Zoe said, we're going to start by just providing a bit of an overview of kind of the immigration considerations here. I anticipate that not many of those on the call will be very familiar with immigration rules in general. And so I thought it'd be good to kind of go through the requirements to an extent and the processes involved, such as it relates to adoption and visas kind of stemming from adoption. The reality is that this is a very complex area of law. Obviously there are many variables in relation to the different types of adoption that Ruth's going to talk to you about later. But what that means is the specific visa applications that we are considering in this context are quite variable as well. Depending on where the adoptive parents are, what nationality they are, where the child is, what nationality the child is, where the adoption is taking place. Far too many permutations for me to deal with everything today, but happily a lot of the requirements and certainly the process kind of all functions at the same level. And so really what I'm hoping to do is just provide you with an overview of that process and of the key considerations that will apply regardless of exactly what type of adoption we're dealing with. And obviously we can tease out some specifics as we move forward. By way of background, the immigration system in the UK is governed by the immigration rules, and the immigration rules are kind of set out into different sections and areas. So, for example, there is a specific section dealing with working visas. There's a specific section dealing with student visas, and also, as you'd expect, a specific section dealing with family visas. Now, for the purpose of kind of those different subsets of immigration rules, adoptive children are considered to be children, essentially are considered to be natural children. So by way of example, within the immigration rules, the definition of a parent includes an adoptive parent. And the reason I'm saying that is because this kind of umbrella family visa, if you will, is what you would be looking at if a child in relation to an adoption was applying for a visa to come and live in the UK. So it's a generic family visa, and that system kind of applies to adoptive children as it would natural children. The other kind of point to make really from the outset is that generic family system is actually split into two kind of subsections further. Now, I'm not going to bore you with a long history lesson here, but suffice to say, the immigration rules changed drastically in 2012. And the post-2012 system introduced Appendix FM, which deals with most family visa type applications. But there was kind of some holdover from the pre-2012 system that is now dealt with in Part 8 of the current immigration rules. And just to flag that any considerations in relation to applications stemming from adoption are actually dealt with by Part 8 rather than Appendix FM. Now, it's just a point to be aware of. It's not something to be too concerned with because, as I say, the procedural aspects are kind of the same across the board. And so let's actually get into the procedural side of things. The way that the immigration system operates, first and foremost, is that an applicant will need to complete an application form. Sounds obvious, and really that process is fairly straightforward. The application form is completed online, and as you might expect, includes in this instance questions about the child in particular, because the child is the visa applicant, the adoptive parents as well, and the nature of their relationship. The form itself is intuitive to a degree, and what that means is that certain questions will prompt additional questions in that particular area, and by the end of the form itself will have identified specific documentation that would be required in that particular visa application. And that's an important point because, as I've said, what we're dealing with is kind of a generic sort of heading of family visa. And so the visa application form would be a form for a child applicant, but it's not really more specific than that to begin with. And so the answers that are provided within the form are then what actually kind of makes the main plank of the application, in the sense that that's where we identify that this is an adoption and what the nature of it is and what documents would be required. So it's an important step in the process, but I also want to caveat that with saying that I chose my words quite carefully earlier when I said it's intuitive to a degree. The reality is that the form simply cannot account for all the different variables, particularly in complex cases, and many visa applications concerning adoption are complex. Consequently, the list of documents that the form provides is not always a definitive list of the relevant documents. And so I think it's very important to be aware of the fact that when dealing with a visa application in the context of adoption, yes, the documents that the form identifies need to be provided, but actually it's usually the case that extra documents will need to be provided above and beyond that. Those documents will obviously vary depending on the specifics of the application. The Home Office guidance provides information about what those documents might be. I don't have the time this morning to speak to every single particular document that might be required, but but by way of overview, what we're really considering here is evidence of identity and evidence of the relationship between the child and the adoptive parents. And so in practice, what that amounts to is the passports are always going to be required for the child and for the parents as well. Ideally, child's birth certificate. And then beyond that, depending on the particular circumstances, some kind of official evidence of the arrangement or relationship involved. So by way of example, if the adoption process is taking place overseas and relevant local authorities are involved in that process and have completed a report relating to that process, that report would be provided. If a guardianship order is in place, the guardianship order would be provided. If the child has been abandoned and is in the care of a relevant authority overseas, a certificate of abandonment. So those are just some ideas for you, some examples in terms of what we might expect for the application. But as I say, the list on the form is non-exhaustive, and every case is different and complex in its own way. And so getting those documents right is always key. Moving back to kind of the process, so the application form's been completed, the documentation such as they are have been identified. The next step is actually then to make payment, to submit the application. The point of submission is the point of payment. Now, again, the specific payment will vary depending on what type of application is being made. So by way of example, if a convention adoption is going to take place in the UK, and so the visa itself is being applied for to facilitate entry to the UK so that the adoption can take place here, that type of application would be for limited leave to remain. The application fee is a little over £1,500, and there's also an immigration health surcharge, which is £624 per year of the visa validity. Alternatively, if the adoption has taken place overseas, let's say a convention adoption, again, just for ease, and the individuals in the UK are perhaps visa holders themselves, they have settled status by way of example, the child would be applying for indefinite leave to enter or indefinite leave to remain in the UK. So it's not a time limited visa, it's a permanent visa. The application fee is a little over £2,400. So as you can see, there's some variation there. The key point really to be aware of is that in terms of actually paying the fee, we're talking about thousands of pounds, and that payment needs to be effected to actually submit the application. Once that has been completed, the final part of the process, if you will, from the point of view of the applicant and obviously any advisors to the applicant, is to submit the documentation and attend a visa appointment. Now, it used to be the case that those two things happened at the same time. Applicant would go to the visa appointment with their documents and provide everything there. That's no longer the way it works. So now, in the vast majority of cases, the documentation can be uploaded beforehand, and then an appointment is booked and attended. And really the purpose of the appointment is just to provide the passport and also have biometric information taken, so photograph and fingerprints. But if the child is 5 or under, fingerprints aren't going to be taken anyway. So it's just an extra step in the process really to hand over a passport, essentially, is what it amounts to. The reason that step is important, though, from a timescale perspective, is that the Home Office do not start dealing with the visa application until the appointment has been attended. Once the appointment has been attended, the official processing period for a family type visa is 12 weeks. So it's a 3-month turnaround, essentially. In practice, in my experience, you're looking at closer to 2 months rather than 3 months. However, at the moment, and obviously this will be relevant for as long as it's relevant. At the moment, because of the situation in Ukraine, the Home Office are pooling their resources elsewhere, which means there are delays across the board with all types of visas that aren't relating to the Ukrainian system, the Ukrainian family scheme. So currently, I'd expect an application to take around about 3 months, if not slightly longer, simply because of the state of the world at the moment. Once that application's been determined, though, the individual can then enter the UK, assuming the application was granted, the individual can enter the UK. What we're really talking about there, and if we boil all of this down, the immigration process itself is going to take a minimum of around about a month when you account for the time it takes to complete the application, attend the appointment, and have a decision made. But in practice, all of those steps are going to take slightly longer. So realistically, I would say that you're looking at, somewhere between 2 and 4 months for the entire process to go through before the child is in the UK. And obviously, those timescales then need to be factored in relation to anything that's happening with the adoption. Now, a couple of final points just to sort of flag before I hand back to Zoe and Ruth. First and foremost, there is an interesting interplay between kind of the immigration aspects and the family aspects here. Obviously, one will inform the other in any of these cases. Which one takes precedence will depend, as I said earlier, on exactly what's happening, because the child might need a visa to get to the UK to actually complete the adoption, or the adoption might have taken place well before a visa is considered. But both elements need to be kind of thought about from the outset and considered in terms of timescale, and that's why I thought it important to go through the timescale there. Interestingly, the Home Office, well, as you might expect, actually have been very clear in their guidance that the visa decision is not indicative of or does not have an impact on any of the family elements. So what I mean by that is there are visa requirements. If they are satisfied, the visa will be granted. If they are not satisfied, the visa will be refused. That doesn't necessarily mean that the Home Office are passing any sort of judgment on the status of the adoption at all. It is just they have their requirements for the visa, and that's all they're really interested in. The Home Office can be quite inflexible most of the time. The final point I wanted to raise is just in relation to British citizenship. Ruth is going to talk to you about different types of adoption, but I just wanted to flag that where we are dealing with convention adoptions, and where that convention adoption takes place either in the UK with British adoptive parents, or outside of the UK where the British adoptive parents are habitually resident in the UK, the child will actually automatically become British upon the adoption. So in those circumstances, visa requirements are either non-existent or no longer relevant, because from that point onwards, the child can obtain a British passport. And that's kind of a general overview for you. Hopefully that's been helpful. I'll hand back to Zoe now to hand you on to Ruth.
Thank you so much, Mark, because that really brought to life a part of the process which I don't necessarily take a deep dive into, and that's really helpful, because I am aware that, you know, I hand over the immigration aspect to somebody else, and I know that takes time, and they're high stakes. It's a high stakes process with huge emotions attached to them. Now, Ruth, I'd like you to start by telling us about domestic adoptions with an international element, and I've been particularly interested in your recent case of Re Y. Partly because of its international elements, but also what I perceive as the changing face of adoption, because we often think about adoption as being a very small child, but that hasn't been your experience, has it? So over to you, Ruth, please.
Thank you. Yes, of course. Well, thank you for inviting me to come and speak to you and the other attendees. It's delightful to be here. But I think you're absolutely right. When most people think of adoption, they're thinking about a small child being adopted, but the conditions for the making of an adoption order, which are contained in Section 49 of the Adoption and Children Act 2002, provide that the court can make an adoption order for a young person, provided that the application is issued before their 18th birthday, and pursuant to Section 47(9), which provides the conditions for the making of an adoption order. The order cannot be made if a child has attained the age of 19. So it's clear that adoption orders can be made, provided they're issued in time, all the way up to a child's 19th birthday. So I think it's important to bear in mind, in every single adoption case, that the lens through which we must analyse the factual matrix when advising our clients and advancing their case it is one that looks at the statutory conditions that have to be met, because adoption is a creature of statute. So there are specific conditions that you have to meet. But if you can meet those specific conditions, then the issue is going to be the welfare of the child, whose welfare is the paramount consideration. And it's their welfare throughout their lives, not just their minority, as it would be with a case under the Children Act. And so where a court is satisfied that an adoption is in the welfare interests of this child, it will make the order. And there aren't rules, there aren't glosses. I think we've all seen in the 20 years of my practice that the Court of Appeal and the Supreme Court have been out there with their paint stripper, removing glosses from statutes left, right and centre. And so it's purely a case of looking at do you meet the criteria in terms of the entry requirements? And if you do, what are the best interests of the child? In terms of ReYP, that was a very interesting case on several levels. And it raised a number of issues that were relating more to the conditions than to the welfare issues. In that case, I acted for the young person YP, and I have to confess that when I was first having my initial conversation with my instructing solicitor, it did appear to me that this case might test the limits, and it was a bit of a long shot. I'm not going to pick up on all of the complexities in that case, because that case threw up challenges at pretty much every level. But there are a few that I think it might well be worthwhile highlighting with you this morning. So one of the issues is that this was a step-parent adoption, which meant that the mother didn't adopt, but she didn't lose her status as parent when her partner adopted YP. And so in order to qualify for this type of adoption, you have to satisfy the court that you are in a couple, and a couple is defined in section 144(4) of the Adoption and Children Act as being as a couple living as partners in an enduring family relationship. Now, the facts of this case were that the mother and the adopter had been married some considerable while ago and had divorced before YP was born. When he was quite young, I think he was about 3, she rekindled her relationship with the adopter, but not in a way that resulted in them cohabiting, and in a way that might, when you looked at the facts, be more construed as a very close friendship rather than a lovers type relationship. So would this be a enduring family relationship where they were living as partners for the purpose of being able to proceed with a step-parent adoption? Ultimately, the court was satisfied that despite their not cohabiting, despite their living largely in different countries, the adopter was primarily based in London, although he had a home in Switzerland, and the mother was primarily based in Switzerland, although she travelled and spent time in the London home with the adopter. And a lot of the time that the family were together as a unit was spent on foreign trips when they took holidays around the world, and finances weren't a problem for them. So that was not something that was a restriction. What the judge said was that she was satisfied that they were in a relationship. And I'm just going to read you what she says at paragraph 83. She said, "The weight of the evidence allows me to find on balance they are living as partners in an enduring relationship. They may live in different homes in separate countries, but they have long-standing commitment to one another. They were married once and they now share the care of YP, both bring him up, both give him emotional support. The adopter helps the child financially as well, and they consider themselves to be a family unit." So that was enough to pass the necessary test of an enduring partners in an enduring family relationship. Another issue that we had to confront in this case was the fact that the child had a relationship with his birth father. He'd known him since he was a baby, and the birth father had been on the scene throughout his life. But in fairness, I think it would be fair to describe the relationship between the child and the birth father as an ambivalent one. They weren't in contact terribly regularly. They mostly communicated by text, sometimes by phone. And the contrast in the de facto relationship between YP and the adopter who was the man that he considered to be his psychological father, the man that he would speak to on a regular basis, spend time with, had a bedroom in his house in London. That was a very close and vivid relationship, whereas the relationship between the child and his father was more one of perhaps an quite extended family member. And when it came to it, the father wasn't entitled under the rules to being given notice of the proceedings. He didn't have PR under English law, so he didn't have the status of a parent for the purposes of Section 52 and the requirement of consent. But he also didn't have PR under foreign law either, so he wasn't obliged to be given notice pursuant to the family proceedings rules, which do oblige notice to be given to a father with foreign PR. However, there's a huge body of case law which says that birth fathers ought to be given notice of proceedings, and local authorities are obliged as part of their investigations in a private adoption to meet with, if possible, and speak to and discuss the adoption with a birth father, whether or not he's got PR. So in this case, the father was given notice of the proceedings. He was given the opportunity to apply for party status. And although he did respond to the social workers, and he, in fairness, expressed the view that he didn't agree with the adoption order, he didn't actually engage with the litigation at any stage. He didn't participate in any of the hearings or seek to. And I think that was a factor which weighed in the mind of the judge when she was assessing the relative strengths of the different relationships in this complicated family. Ultimately, the court was satisfied that making the order was in his best interest. The issue, which took me a bit by surprise, that the judge was most worried about, was the question of whether or not the requirement of Section 42(3), that the child had to have his home with the adopter for the 6 months preceding the issuing of the application, whether that was in fact met. And it arose because, rather unfortunately, COVID had struck, and travel between London and Switzerland, in fact, travel between London and anywhere, including Norfolk, was problematic. So the boy hadn't been over to spend time in the home of the adopter in that 6-month period. But the court was taken to a number of cases, both within the context of surrogacy and human rights, but also within the context of adoption, where it is clear that it is perfectly appropriate for a court to take a very wide and broad purposive interpretation of the meaning of the word home. And in particular, one of the cases I took the judge to was the case of Reeve G from 2008, where the court was specifically looking at what does it mean for a child to have their home with an adopter. In that case, it was a Section 84 of the Adoption Children Act, so it was the 10 weeks preceding the application. But the principle is exactly the same in Section 49, in Section 42 rather, where it's having your home before the issuing of an application for adoption. And so at the end of it, the judge was satisfied that this criteria was also met. And I'll just read you what she says there. She says, "I have no doubt that there is a family tie between the adopter and the young person. In my judgment, this is a situation where the court should act to enable that tie, those family rights to be maintained. The concept of home should be given a wide and flexible interpretation. This is not a case where a particular geographical location is required. I do not consider that R and YP need to be living with A in one place for YP to have a home with A. I've concluded that the home in this context of an 18-year-old who has known the applicant almost all his life, who is bound to him emotionally and sometimes geographically, and regards him as his father, meets the requirement of having had his home with the applicant at all times during the period of 6 months preceding the application, even though YP was in Switzerland during this period." So again, what I think that draws out is that where the welfare requires the making of the order, the court will take a flexible approach to the interpretation of the conditions when it is looking to see whether or not those conditions are met in a particular case. Now, one of the things that didn't arise in YP's case was the issue of citizenship. YP was a Swiss citizen. The adopter was also Swiss. Nobody was British, but also, more importantly, by the date of the application, YP had already turned 18. Citizenship through adoption is conferred by Section 1 of the this time it's the British Nationality Act 1981. And so if you are adopted in a UK court or in a court in the Channel Islands or the Isle of Man, upon the making of that adoption order, if one of your adopters is British, you acquire British citizenship automatically. And if you are, as Mark said, if you are adopted under the convention in a foreign country, while the adopters are habitually resident in this country, then again, the child acquires British citizenship automatically. But British citizenship doesn't follow automatically if the adoption is, well, it doesn't follow at all if the child is 18, and it doesn't follow if it's an overseas adoption. And we're going to look at those later. I can see that they're on Zoe's list of questions for me. So in this case, immigration wasn't a problem because the child was never going to get it in any event. In a case where citizenship would be conferred by the making of an order, then it is a requirement to give notice to the Secretary of State for the Home Department so that they can, if they wish to, intervene in the proceedings if they feel that there are any good reasons why an adoption order shouldn't be made. And there have been cases where that has happened. In the case of FAS and the Secretary of State for the Home Department and another, which is a 2015 case, the weekly law report reference is 2016, One Weekly Law Reports 407, and the neutral citation is EWCA Civ 951, and that's a 2015 reference. What happened there was that the child was under 18 at the time, and they would acquire citizenship, and the Secretary of State was of the view that the making of the adoption order shouldn't be a way of controlling the immigration, that the Home Office should have the ultimate say over citizenship. The Court of Appeal didn't agree, and I'll just read you out what they said. They said, if taking account, this is at paragraph 42 of the judgment, if taking account of the practical benefits of adoption for a child throughout his life, it can be seen that it best promotes the child's welfare that he be adopted by a British citizen so as to automatically to acquire British citizenship under Section 1(5) of the 1981 Act. The court should ordinarily make the adoption order which is sought. Just as for the first of the periods considered by Lord Hoffman in the context, so he's referring to an earlier case in Reeve, the state's interest in maintaining effective immigration controls will have very little significance. It will not be appropriate for a court to refuse to make an order as some sort of indirect means of reinforcing immigration controls. And he goes on to make the point even further. I can readily see that the Secretary of State for the Home Department might be concerned at this result, but if she wishes the courts to have the ability to give greater weight to considerations of immigration policy in the context of deciding whether an adoption order should be made, she will need to persuade Parliament to change Section 1 of the 2002 Act to allow that to happen. So it's absolutely clear in that judgment that if there is a conflict between immigration policy and the child's welfare is the trump card and will prevail, and the adoption order should be made. So those, I think, are the key things that come out of ReYP.
Thank you, Ruth. And if I may say, I think that young person was fortunate to have you on his team for leading that case, because, you know, it just really takes a creative and robust approach, which you're known for, to get that across the line, because it's unusual, and it really did make me sit up and think. And so thank you. Right, hopefully this is an easy question for you. What is a convention adoption, please, Ruth?
So a convention adoption is an order that is made in compliance with the 1993 Hague Convention on Intercountry Adoption. And they can be convention adoptions where the with a convention adoption, you have the state of origin, which is the state where the child lives, and you have the receiving state, which is the state where the adopters are habitually resident. And so a convention adoption can be made when we are the child's state of origin, and it can also be made when a different member state is the child's state of origin. Because we're looking here at incoming adoptions, I'm going to be focusing on the processes involved where the child's state of origin is not here. You will find the process for convention adoptions where we are the receiving state, set out in Part 3 of the Adoption with the Foreign Elements Regulations, and it's Chapter 1 of Part 3. When you're looking at a convention adoption, in fact, when you're looking at an intercountry adoption, either under the convention or otherwise, you have to have your fingers in a number of different instruments. You have to be looking at the Adoption and Children Act 2002, the Adoption with the Foreign Elements Regulations 2005, the Adoption Act, the Adoption Agencies Regulations 2005, and between those instruments, they provide a coherent framework insofar as the AFA regulations amend and supplement the provisions in the Adoption Agency Regulations and the Adoption and Children Act. So it is slightly complicated when you first start looking at it, but the key thing with a convention adoption is that you are looking at Part 3, Chapter 1 for your rulebook, I suppose, in a way. So if you have a client come in and they say to you that they want to adopt a child from another member state, what they will need to do is approach their local authority and ask to be assessed as an adopter in accordance with Article 15 of the Convention. Either that authority will do it themselves or they will refer them off to the International Adoption Centre. And there is usually a charge for that. It's not a free assessment as it would be if you were applying to be a domestic adopter. That process can take some time. I think it can take sometimes up to about a year. But once you're approved, the local authority or the International Adoption Centre will send a report off to the DFE, and the DFE will check that everything has been done properly and all of the regulations have been complied with. And they will then send the Article 15 report off to the state of origin for the country that you've been approved for. And you get approved for particular countries. You can be approved for more than one country, but you don't just get approved to adopt a child from any member state randomly. The central authority in the child's state of origin will then look at the Article 15 report. They will consult their list, which will have all of the children who've been approved for adoption under the convention, and they will see if there's a match. If there's a match, then they'll send the child's report, which is called an Article 16 report, back to the DFE, and the DFE will then send that on to the adoption agency, who takes it to the adopters. The adopters are then counselled and given advice around it. And if the adopters want to proceed with the adoption, then the recommendation is made that and if the agency thinks that it's a good match, the recommendation is made that it should happen. Once both the child's state of origin and the DFE here have agreed that the adoption is in the child's best interest, they will certify that agreement, and that's called the Article 17C agreement. And after that has been given, the adopter is then permitted to go and meet the child and bring the child home. One of the things that has to happen when the DFE gives its authorization for the adoption to proceed is it also has to confirm to the child's state of origin that following the making of a convention adoption order, the child will be allowed to enter and permanently reside in this country. I understand, having seen one of those forms, that in fact we don't give that exact wording, but we give an assurance which is just slightly short of that. But the obligation under the convention, which comes in from Article 5, is that the child will be allowed to enter and permanently reside here. And it's one of the wonderful features of the convention, in that the historic problems of children who are stranded in foreign countries, having been adopted by somebody who can't then get immigration, is a thing of the past, because it is all part and parcel of it. I think it's like a pre-approval was how the New Zealand immigration expert understood it to be. But anyway, as Mark said, once you've got a convention adoption, you don't need to worry about immigration, because if one of you is British, the child is going to be a British citizen. If one of you isn't British, then the child in any event will be given the permanent visa to live in this country indefinitely. So either way, the immigration issue shouldn't be problematic. If you so there's two ways of doing it. You can have your adoption under the convention in the foreign country, or you can bring the child back here and have the convention adoption here. Either way, if you haven't already adopted in the foreign country when the child enters this jurisdiction, you have to notify your local authority. And once a local authority is notified that a child has entered into the jurisdiction for the purposes of a convention adoption, they then have an obligation to monitor and support the placement. And if ultimately the probationary period is being undertaken in this jurisdiction, the local authority will provide reports for the foreign courts. If the adoption is going to be carried out here, then it will be providing its assessments and support, and will ultimately be responsible for providing the Annex A report, or I should probably say Rule 1411 report, as they're now known, at the end of the case. Yes, I think.
Thank you.
What was probably the key points, and I'm conscious of time.
Yeah, no, that was really good. I'm pleased you still call them Annex A reports instead of Rule 1411. But yeah, so the next scenario I'd like you to tell us about is where an overseas adoption has taken place, but the Hague Convention on Intercountry Adoption 1993 does not apply.
So overseas adoptions is a term of art. We find it in section 66 of the Adoption and Children Act. And an overseas adoption is an adoption that takes place when the adoption is made under the domestic law of a country that is on the designated list. That list is contained in the Adoptions Recognition of Overseas Adoptions Order 2013. The list contains pretty much all of the countries that are member states of the 1993 Hague Convention, and it replaced the previous designated list, which contained mostly countries in the Commonwealth, plus some notable additions like all of the European countries and the United States. Pretty much all of the countries that were on the list before 2013 remained on the list after 2013, but a lot more were added. I think Singapore is one of the, I think there might be another one, but Singapore is one of the odd countries that fell off the list in 2013. So if an adoption takes place under the domestic law of a country on that list, then it's an overseas adoption. And that is significant because Section 67 of the Adoption and Children Act provides that the parent and child relationship is recognised automatically in this jurisdiction, and there's no recognition process required. What is different between an overseas adoption and a domestic adoption or a convention adoption is that whether or not one of the adopters is British, the child won't automatically acquire British citizenship. And that comes in via Section 74, which expressly says that the provisions of that section 67 doesn't have effect for the purposes of immigration or the British Nationality Act 1981. And so if you don't get your citizenship through section 1 of the British Nationality Act, you're not going to get it as a result of the adoption. There is an interesting overlap, I think, between, and it's not an accident, between the provisions of the 1993 Hague Convention, section 66, and section 83 of the Adoption and Children Act. I'm going to come on to section 83 in a bit more detail in a few moments. But basically what section 83 creates is an obligation that if you are bringing a child into the country for the purposes of adoption, or you are bringing a child into the country following the making of a foreign adoption order within 12 months of the making of that order, and you are a person yourself who is habitually resident in this country, then you have to comply with certain regulations in AFA. What would happen with a overseas adoption is, because those countries are all on the all member states of the Hague Convention, is they should really only be doing adoptions if both the adopters and the child are habitually resident in their country. Because if the child or the adopters were the child and the adopters were resident in different countries, then it ought to be an adoption that proceeds under the Hague Convention. So because the child and the adopters are both resident in the foreign country together, when the child is brought into this country following the adoption, it won't be in breach of section 83, because the adopters wouldn't be habitually resident in this country when they were bringing the child in. They might be bringing the child in and all of them acquiring habitual residence here pretty sharpish soon after, but at the point of entry, they will be leaving the country where they were habitually resident and coming in with the child. So take an example. The Philippines is a country that is on the designated list. If you have a family that's gone over, they're living in the Philippines, one of them is British, for example, and they adopt some children who are habitually resident in the Philippines, and then several years later, they come back to this country with the children won't be British, and the children would need visas, but the adoptive status would be recognised, and I envisage that would make it much easier for them to get a family visa in the way that Mark was talking about earlier. So I think that covers briefly overseas adoptions.
Thank you, Ruth. It's a very complex area, and I've heard you speak about it and read your book on it, and I still find it complex. So thank you very much. Okay, so can you tell us about a domestic adoption where it takes place here, where the child has been brought into the UK for the purposes of adoption?
Okay, so there are some countries that are not on the designated list, and there are also cases where the adopters are living in this country and they have either adopted a child overseas or they want to bring the child into this jurisdiction to adopt them here. And the key difference there to the overseas adoptions is that the adopters are habitually resident in this country. And so if they don't have an overseas adoption, because let's say it's a Russian adoption, or for example, it's a Moroccan kafala order, when they bring the children into this country, they will then be looking to adopt them in this country to acquire the status of parent and child. And these are the cases to which Section 83 of the Adoption and Children Act will apply. And in such cases, the regulations in Part 2, Chapter 1 of AFA govern the assessment and placement and entry of the child into the UK. And I think the majority of cases that I've done, for whatever reason, seem to be cases where those regulations haven't been followed in full. So what is required under the regulations is that if a person who's habitually resident in the UK is contemplating adopting a child from overseas, they need to be assessed and approved to be adopters here first. So they would go to their local authority and they say, I'd like to be assessed to adopt. I'm thinking of going over to Morocco and having a child placed with me under kafala, and then I want to bring them here and I would need to adopt them here. And so the local authority either themselves would adopt them or they would send them off to the International Adoption Centre to be assessed. We don't have to involve the DfE in terms of the approval of the adopters because it's not a convention adoption. But we do, in the DfE, well, the Secretary of State for our Home Department does get involved because at a later stage. So first of all, you're approved, then you're supposed to liaise with the Foreign Adoption Agency, and then the Foreign Adoption Agency sends details of children over. And then when you've had some counselling from the local authority about the child's details, and the adopters have decided that they want to proceed, at that stage, they get permission from the Home Office to go out and meet the child and bring the child back. And again, that's a sort of pre-approval process. Once that has happened, there is then permission from the Secretary of State for you to go and meet the child. And so you meet the child, you go through whatever adoption process or kafala process or guardianship or relinquishment process that there is in the foreign country, and you're then bringing the child in. And again, you've got this pre-approval, so that should help to fast track the visa application if you've complied with the regulatory framework. And when you come to this country, you give notice to the local authority within a fortnight, and if you've complied with all the rules, you can apply for a domestic adoption order within 6 months of the child having their home with you. If you haven't complied, then you have to wait for 12 months after you've arrived and given notice to the local authority. The problem, I think, is that people who don't go and seek advice at an early stage from a lawyer are unaware of the AFA regulations. And so what they imagine they need to do in the stories, the many stories that I've come across, is they find out about how you go about the process of having a child placed with you lawfully in the country where you are seeking to adopt a child from. And so usually in all those cases I've seen, the adopters have gone out to the country, they've worked honestly and transparently, they've complied with all the relevant regulations in the child's country, and the child has been placed with them either under a kafala or an adoption order, etc. Or guardianship. Sometimes I think I did a case where it was India and it was a guardianship order. And then they bring the child here, or try to, and that's when they start to make their visa application. And that's when the fact that they haven't complied with Section 83 can cause them a bit of a problem. It doesn't always. I mean, I have had cases where the first time that the adopters realize that they are facing some difficulty because they've not been compliant with AFA is when they issue their application in the British court, or they are not always told actually when they speak to the local authority either. But it is a problem. It is a problem which has to be looked at if there's been a breach of Section 83. It's not a fatal problem because the criteria for making an adoption order is the welfare checklist in Section 1, and Section 1 doesn't mention Section 83. There is the potential for a prosecution if there is a breach of Section 83. But to my knowledge, and also to Catherine Cronin's, who's been doing this even longer than I have, there haven't been any prosecutions under Section 83. Possibly because Section 83, in the parts that create the criminal offence of breaching Section 83, is drafted very badly in terms of creating certainty of what the criminal offence is. And apparently that is a defence in the criminal courts, not that I would know because I've never practised in crime and I haven't studied it since the early 1990s. But so what I would say, the key point I think that I would like to convey in the 3 short minutes that I've got left is if you have a case come in and the people are asking for advice at a very early stage before they've met a child, draw their attention to the regulations in section in AFA in chapter 1 of part 2 of AFA, so that they get themselves assessed and they can do everything properly by the book. It will be much more straightforward for them if they do. But if you get them when they say, we've arrived, here is our child, we got our visa, we have done everything right, but now somebody is telling me that we've got it wrong, somebody at the local authority or somebody at the court, don't panic. It's not irretrievable or fatal to their case. You just need to unravel it all, set it out before the court, and draw the court's attention to case law, which confirms that adoption orders can be made if they're in the child's best interest, notwithstanding a breach of Section 83. So that was a bit of a whistle-stop tour of quite a complex issue, but I hope it makes sense.
Thank you so much. I haven't had any questions pop up, so if anyone wanted to pop in any questions, and we've got a final 2 minutes left, and thank you both, Mark and Ruth, for sticking so well to the time and for covering such, what's a huge topic in this time. I don't know if, Ruth, you wanted to briefly speak about declarations recognising a foreign adoption, or you've already touched on some of it. Oh, hang on, just one moment.
I don't mind. I can do. I've got some a bit of a short. Yes, it's not very long, my response to that, because I knew that we would be running short of time. But I can run through it if it would help.
But we also do have a question in about YP, which is an interesting question about. I know the answer to that. I don't know if you've seen the question from Alice, Ruth.
Let me just see if I can see the questions.
But if I read it out.
I can see it now. Yep, from Alison.
Should I read it out so that our audience can, because I don't know that our audience can see it. So in re-YP, why did the prospective father, adoptive father, seek an English adoption order when the child YP and the mother were living in Switzerland and father was Swiss? Was it because it wasn't possible to get an adoption order in Switzerland?
Well, it's a very interesting question. I don't know the actual answer to it because I wasn't acting for him. But what I do know is that he was here and he was domiciled here, and I think it was, well, my suspicion, I can't say for certain, but my strong suspicion is that it had something to do with the fact that under Swiss law there are rights in terms of inheritance when it comes to children, and so the adoptive father wanted to make sure that his son, and the only one of his 3 children with whom he had a close and ongoing relationship, wouldn't be facing issues in terms of inheritance when he died, and he had quite a lot of assets to pass on. So I think that was a part of it, and we did double check that the English adoption order would be capable of being recognised for the purposes of the inheritance law in Switzerland and also the inheritance law here. So I think that was why it was. But yeah, I don't know what the Swiss law is on adoption. But what I can say is, if the law in Switzerland had made it an impossibility, again, that would be unlikely to be a reason why this court would have declined it.
Yeah, thank you, Ruth. And it is interesting because it is that question, well, why bother? And there are lots of reasons that our family clients come to us that an adoption or a status or a certain recognition of a family life is important, even though you think, well, what practically does it achieve for you? But that's there, it may practically, as you've speculated, achieve something related to finances, but also there is that important recognition of your family status.
I mean, in many ways, I think of adoption as being quite similar to marriage, except that it's not dissolved in the same straightforward way.
No.
But people get married. Sometimes there aren't any practical differences, apart from perhaps death tax. But it is important to them, to their feeling of how they are as a family and to the way that the rest of the world reacts and relates to you, to have that official legal recognition. And I think you see that a lot with, I mean, there are families who have declined to have adoption orders when they feel that they should have parental orders, which are marginally different. But it has been enough for some cases. There was that quite interesting case, the name of which currently escapes me, but where Mrs. Justice Tice was unable to make a parental order because the surrogate was refusing to consent. She wasn't looking to disturb the placement, but she wouldn't give her consent for various somewhat capricious reasons. And the adopter, well, the intended parents, as far as I know, they never went down the road of adoption because what they wanted was a parental order. And again, that's all about the status and the importance psychologically of having the right status for your situation, reflecting the reality of it.
Thank you, Ruth, and Mark, and I think that's what's so interesting about ReYP, and also the cases we're all dealing with in relation to surrogacy as well, the changing landscape. Because I think, you know, the welfare test is so broad, but I think I've evolved in my practice in that, you know, I started off thinking, well, why is this necessary? Why is it necessary to discharge that legal relationship with the birth parent, even if they have a stronger relationship with the step parent? Why is that necessary? Why do we need to persuade, make an application to court to discharge that? And I think that's what for me, ReYP was a very significant case, that it's about evolving society needs, and the recognition of the family is so important. Thank you very much. We haven't run over too much, haven't got any more questions, so I'd just like to thank Ruth and Mark again, and Sarah also for your support in the background. Thanks very much. I'm going to bring this to a close. Have a great Thursday, everyone.